then move on to HB 2460. But before we get started with HB 2705, just wanted to check with our tech staff to see if perhaps Representative Rajes was online. Thank you. Just a moment. Stand at ease just for a second. If while I'm trying to contact Representative Rajes, if the revisor could maybe do just a brief overview of HB 2705. Yeah.
Good afternoon, Mr. Chairman and members of the committee. We might recall that House Bill 2705 authorizes the Board of Regents on behalf of Kansas State University to sell a piece of property in Manhattan in Riley County, and the address is generally known as 1930 College Heights Road. And then probably the only thing to note is sometimes we say where the money is specifically deposited and sometimes we don't. But in this instance, the proceeds of the sale will be deposited in the Housing System Repair Equipment and Improvement Fund of Kansas State University. The bill contains basically sometimes what we refer to as boilerplate. So the Attorney General will review all the deeds to be sure it's legally sufficient, that we are selling the right piece of property. And so they'll review the deeds. And then this is not subject to the appraisal statutes, because sometimes the legislature wants to do an appraisal and it's not subject to the surplus real estate, which in the past, monies went to different pots, but now really it just goes to the agency that's selling it. So I'd be pleased to stand for any questions.
Are there any questions for Jill? Representative Fairchild.
Thank you, Mr. Chairman. I'm not sure if this is a question for you or just a question for anybody, but why are we having to hear this again and vote on it again when we voted it out before anyway?
If you'd like to offer that explanation, that's fine.
So the bill did pass out of committee. It was on GO for turnaround. It was not, as we technically refer to it as being blessed. So it needed to be sent to Appropriations Committee, and then it was sent back here. And then for your pleasure, whatever you do. So the reason it got sent back here, sir, is it was blessed and then sent back.
Well, I serve on the Ag Committee, and we have a couple bills I think that were blessed. And, after they were blessed, I thought they just basically went back above the line again. And we didn't, hear those again and do those over again.
I think it depends on the bills. For this bill in particular, we just didn't get to it before turnaround. So it was blessed and referred back to our committee. We have to go through the formality of voting on it again to get it out of committee, so there can be a committee report, and then it would be considered, well, up to the leadership if they bring it above the line. So it just allows us to keep the bill alive to avoid the turnaround deadline. Any other questions from members of the committee for HB 2705? Representative Woodard. Representative Woodard.
Thank you, Mr. Chair. I move that we pass out House Bill 2705 favorable for passage.
It's been moved and seconded to pass out House Bill 2705. Is there any discussion on the bill? If not, we'll proceed to vote. All in favor of, would you like to close on your motion?
Mr. Chair, I close.
I'm sorry, Representative. It's been moved and seconded to pass out House Bill 2705. All in favor signify by saying aye. All opposed, nay. Motion carries. So now we can move on to HB 2460. You should have a copy of the bill as written today. I just wanted to start off with maybe some brief remarks. So my intention on this bill was never to be punitive in nature, but it was to address what I would deem as a discriminatory practice of requiring applicants for employment or conditioning employment to these statements. And I believe there is a constitutional precedent that would deem these statements as compelled, compelling speech, basically. And we heard that in the proponent testimony by the Foundation for Individual Rights and Expression, and they outlined their constitutional concerns there. So what I would like to do is consider a balloon amendment to HB 2460. But before doing that, I believe their Representative Fairchild had an amendment, and so I had told Representative Fairchild that I would allow him to introduce his first. So if the revisor could hand out a copy of the Fairchild amendment. And Representative Fairchild, if you would like to begin explaining your amendment as it's being handed out.
Thank you, Mr. Chairman. When we had a hearing on this, we received testimony from a young lady who went to KU who basically said that she had been discriminated against when she applied for a job on campus at KU. And back then I asked the question of whether this bill would apply to that situation, and I was told that it would not apply to her situation. And so this amendment is just to make the bill apply to that situation, and it would put language in saying hiring an applicant for employment. And so the language of this bill would apply to employment both on campus and off campus. And it would just apply to the bill to that situation, to jobs on and off campus, university jobs, both for the students and for anybody else on who works for the university in any way. Basically, the young lady from KU had said that she was asked several questions, basically trying to get her to say that she supported diversity, equity, inclusion, and she felt like she had to answer the question in that way in order to get her job. And so this amendment is just to try to prohibit that type of discrimination from occurring.
Thank you, Representative Fairchild. I did have a question for the revisor. Well, would you like to make a motion, Representative?
Thank you, Mr. Chairman. I move that I introduce this amendment.
Okay, so Representative Fairchild moves and his amendment, and it's received a second by Vice Chair Sanders. Discussion on the amendment or questions for the revisor. Representative Woodard.
Thank you, Mr. Chair. Not specifically to the contents of this amendment, however, based on those comments, I do want to make sure for the record, everyone knows the student that testified is a student employee at the University of Kansas Athletics, which is a private corporation. This bill does not apply. And so I would hope that you will make your decisions on this bill, not based on that testimony that this bill wouldn't even apply to. Thank you, Mr. Chair.
Thank you, Representative. So my question to the revisor would be, does this guarantee equal application of the law if this were enacted for all employees at a university? Is that it would cover faculty, non-faculty, and student employment positions?
Yes, Mr. Chairman, this bill would apply to students apply for admission, any person hiring, or excuse me, applying for a job there for employment at the post-secondary regional, or excuse me, post-secondary educational institutions, and somebody hiring, applying for a job, being reappointed or promoted as a faculty member.
Thank you for that, Jill. I would consider it a friendly amendment to the bill. Is there any other questions or Representative Rajas?
Thank you, Mr. Chairman. So for work study, are students considered employees, or is that, it's been 40 years now. So I don't remember. Back then, I think we were 35 cents an hour, but I guess it's one because, as we talk about this, so hiring an applicant for employment, because it says applicant for admission, then hiring. So where's work study fall in this? I guess that's one of my questions. Would that be considered aid, which is already in there, or?
I believe work study employment would be considered as a university employee. When I went to university, I was considered an employee of the university. I think it's how it's funded, perhaps because of the federal dollars that would.
Okay, Mr. Chairman, do we know currently students at our region institutions, if they apply for work study, they go through the process of DEI before they get approved for work study?
I don't know if that's the case. I think the intent behind perhaps the Fairchild Amendment is to, if we're going to offer this, it should be for all employment. What I found over the course of the last year, the problem areas seem to be with faculty positions, not necessarily someone who's applying for a position under, say, the Division of Facilities or those operational jobs. However, I think it's good to maybe cover everybody under the same provisions rather than single out faculty or non-faculty or make exceptions for students or the like. I think it's just more clear for the university to look at it for all employment.
Mr. Chairman, if I may, I don't want to belabor the fact, but so these words, hiring an applicant for employment, in your mind, that covers, that's not just students, that's anybody that applies for a job at any of the Regents institutions, on campus, off main, I'm just trying to sure exactly what this, I was assuming it was just for students, but it's not, correct?
Representative Fairchild.
Thank you, Mr. Chairman. No, it would just be for anyone who has who's applying for a job, for a university job, both on campus and off campus. Originally, I just had an amendment for on campus, but then Representative, the chairman and I basically got together and discussed this because we both had similar amendments, and his amendment, he had one that went a little further and applied to both on campus and off campus. And so that's what we decided to go along with, was one that he was originally going to introduce. And I decided to go ahead and introduce this amendment, but it would basically it would apply to everyone who's applying for a university job, both on campus and off campus.
Okay, Mr. Chairman, but go ahead, because you maybe the other representative
Representative Woodard.
That's the question I made.
Thank you, Mr. Chair. I think people are using terms that may, when we're referring to off-campus positions, those are private employment opportunities. So this would not apply to that. Are you talking to like additional campuses, like extension offices and things? Those are still campus positions.
Okay, that's what I'm referring to. I mean, off of the main campus, I mean, I don't know what you would call the other places, auxiliary campuses, but I'm just saying it's not just going to be on the main campus, but also any campus that's a smaller, that's not on the main campus.
It's been 11 years for me, but When I was student body VP, when we would hire our student cabinet, we didn't even know, probably for good reason, we didn't know if someone was work study eligible until after we hired them. I think that was in an attempt to make sure that you weren't hiring people based on their work study status. Thank you, Mr. Chair.
Thank you, Representative Fairchild.
Thank you, Mr. Chairman. I just want to clarify, this amendment isn't applying to any type of private jobs or anything like that. And I would not be supportive of applying this to private businesses or anything like that. This is just purely university jobs.
Thank you, Representative. Is there any further discussion on the Fairchild Amendment? Seeing none, Representative Fairchild, you may close.
Thank you, Mr. Chairman. I move my amendment.
Okay, it's been moved. Fairchild Amendment, all in favor of the amendment signify by saying aye. Aye. All opposed, nay. Motion carries. Next, I would like to offer an amendment to HB 2460, and that'll be distributed to the committee. We do have some extra copies for anybody attending the committee meeting today.
Mr. Chairman, I'd like to second your motion.
So it's been moved and seconded for, I guess, what would be called the Howe amendment or proposed amendment number 7. The reason it says number 7 is because I went through a lot of rounds of negotiations and trying to find maybe a better compromise, if you will, on some of the concerns that were brought to my attention 2 days ago in committee. The chair definitely listened to a lot of the comments that were being made in committee, as well as my meetings with stakeholders that would be affected by House Bill 2460. So if I may, I would like to go through the bill, but I don't know if Jill would like to do that, since you're the consummate professional that has experience doing that, and I would be glad to follow up with any questions about the intent behind different aspects of this balloon amendment.
First, thank you, Mr. Chairman. The first amendment on the bill shows up as the title. And so we might all recall the Constitution requires a bill to have a title that describes what's in the bill. So when you see amendments to the title, that's what the revisor is doing there. We're trying to amend the title based on what is going on in the bill. So that's just a brief highlight of that you'd see there. Then on the first page, we are striking in 2 instances or related topics. So we would just all have a statement regarding diversity, equity, inclusion, or patriotism. It would not be any other topics. It would just be those 4 topics on a statement or pledge in regard to that. So then on the next page, we might recall that this set up a action plan sort of what would happen if somebody felt their rights were violated under this section of the bill. And so what this amendment does is really establishes what is going to happen. So if you believe that your rights were violated pursuant to this section, what you would do is you would file a complaint with the Board of Regents. And then the board would have 45 days to conduct that investigation. And then if the board determines that a post-secondary educational institution has violated the section, so they have found after 45 days of investigation the KBOR has found there's a violation, then the institution that's found in violation has 90 days to remedy the violation. So they're on notice that they have been found to be violated, and so they are to remedy that situation. If they do not remedy the situation within 90 days, the board shall report this action or lack of action to the Attorney General, who then can file in district court for declaratory relief or to enjoin the violation, to provide an injunction for a violation. If the board determines after that 45-day investigation that the educational institution has not violated this section, then the person still has another avenue. They can file with the Attorney General. And then the Attorney General has 45 days. Again, same amount of investigation time. The Attorney General has 45 days to investigate the matter. And then if the Attorney General determines after that investigation that the post-secondary institution has violated the section, then again, the post-secondary educational institution has 90 days after such determination to remedy the violation. And then again, if they fail to, within that 90 days, to remedy the violation, then the Attorney General can also then may file an action in district court. This just says that the action will be filed in district court of the county where the post-secondary educational's primary campus is located. So, for example, Fort Hays, you would be filing in Alice County, Douglas, or excuse me, the University of Kansas, you'd file at Douglas. So that is that. And then the next sentence just clarifies that if a district court has actually done an order of enforcement, that any district court could enforce it. So, for example, K-State someone filed in, or the Attorney General filed in Riley County. K-State has an extension office in Thomas County. The Thomas County judge could enforce that if it was happening at the Ag Experiment Station in Thomas County, just for an example, so we could sort of understand what that means. Then if the district court finds that the educational institution has violated this section, the district court shall enter an order requiring the institution to comply, impose a civil penalty on an amount of no more than $10,000 for each violation, and then require the institution to pay Attorney General expenses and costs incurred in enforcing that. And then it goes on further. If the court finds that the institution violation was not made in good faith and was made reasonable effort. So there would be a chance that maybe, let's just play this out, an institution could be fined $5,000, but they wouldn't have to pay Attorney General's costs because the court found there were some other circumstances where they didn't believe that they should have to reimburse for the expenses. So that's just sort of how that would play out if that happened. Then it specifically says, so under KSA 2350 specifically says how fines and penalties go into the state treasury and then get disbursed. For this instance, we want to say that is not what happens, that any civil penalty that up to $10,000 would be remitted to the state treasurer and deposited in the State Board of Regents State Scholarship Program account. And so those monies, if they were fined, they would be into that scholarship account to be dispersed under that scholarship program. Then this says on or before January 12th of 2026, and then annually. So we're going to have an annual report to the legislature. And this report shall be submitted by the regents, and they'll submit a report on the following matters. So basically, how many complaints were filed, what was the resolution of the complaint, how many complaints were filed with the AG, the resolution of those, if it went to court, what the resolution of that was, and then any civil fines. So the legislature would get a report on that. And then it's also a catch-all of any other information that the regents deems pertinent that you might find interesting that they were looking at and find. And then subsection J, within 10 days after the determination by the Board of Regents, then the board shall post on their website the findings and outcomes of the investigation and the determination on each complaint. And then it clarifies there that if Jill Walters was the one who was making the complaint, my personal identification would not be shared with it. I would, I just might be, female X or something. But the information, it would say female X filed the complaint and here was the resolve. So if you so desired to find out that information, that you would have it available to find out before the year when you would get your compiled report of all the information from that previous fiscal year. And then, and just to clarify that there was also, under the former bill, there was an administrative penalty of up to $100,000. That is gone. That has been stricken. So you can see there on page 2, in line 17 through 31, those were stricken. And there was another provision about like the complainant could get attorney's fees, but that is stricken too. So if I would have hired, in this instance, if I would hire an attorney under this circumstance, I would be paying for it myself. But there's no, you might want to hire an attorney, but there's no requirement to, or, I could just fill out the paperwork on my own as a student or applicant for a job, and I wouldn't need to hire an attorney. But I just wanted to clarify that there was language in this bill as originally drafted, and that is gone. So I'd be pleased to try to answer any of your questions.
Are there any committee member questions for the reviser? Representative Fairchild.
Thank you, Mr. Chairman. Would you be able to give any sort of example of what actions the Board of Regents would have to take in order to remedy the situation?
So I think under a court or Board of Regents finding or Attorney General finding, I would envision, now I can't of course speak for the Attorney General then, but what I would envision happening is you found that when I was filling out an application, it said, share with us an experience you had with a diverse group. And if the institution or if the board or the Attorney General or the court found that was in violation, then you as an institution would need to pull that information. And so I don't know if there'd be like 2 spot checks, sir, or 3 spot checks, but I think you would be wanting to do something to be sure that they followed up with that, or if there was something on a website that was in violation of this, that as an applicant I was seeing, that you would want to double check that if it was found in violation, that you would want to double check that was down, and maybe do a, like just your due diligence of like a 2-month check later to be sure it didn't show back up.
Are there any further questions for the reviser at this time? If Representative Smith.
Mr. Chair. On the front page, Jill, on number let's see, line 11, support or opposition to any political movement, including a pledge or statement regarding diversity, equity, inclusion, or patriotism. We talked about that real quick the other day. Patriotism, sometimes don't people that come back from the military get some type of benefit? Maybe I'm clear off with what I'm saying. I just thank you, Mr. Chair.
Representative, are you looking for clarification of why patriotism is there? Okay, so patriotism was put in there to demonstrate that any political ideology, so it's kind of to demonstrate that you could fill in the blank. It could be anything really as it relates to some sort of an ideology. It could be something to do with your view on capitalism or communism or socialism. You could fill in the blank with anything. It could be republicanism or anything like that. It could be your commitment to Judeo-Christian values. These are all hypotheticals, but it is to demonstrate that just because today we're identifying diversity, equity, and inclusion doesn't mean tomorrow, perhaps, there could be something else that turns out to be a discriminatory practice to those that are seeking employment in a publicly held institution.
Thank
you. Representative Rogers.
Thank you, Mr. Chairman. I apologize for missing the discussion the other day. We were doing another committee I had to be in. So kind of speaking of that, if that's an example word, and is this just dealing with applications, or it also says maybe faculty member to get a promotion or something? So if I'm a faculty member, or I'm in the janitor's closet and I have the "In God We Trust" poster on my wall, or "God Bless America," am I now out of, is that do I get the university in trouble because I'm displaying that? Or I just want to make sure I understand, because we could have another, I hope not, but a situation where we have a swelling of patriotism, and say the leader of the CEO of the university says it's okay to wear flag pins or to show patriotism, as a way to unite. I just want to make sure you explain, please. Thank you.
Representative, question directed towards the
Yes.
chair or Jill?
I'm sorry.
Okay, I didn't know if
Whoever won or whoever wants to answer that.
I could take a first crack at it, and you can clean up to see if I'm messing it up, Jill. But displaying a flag, say in your office, or like you had mentioned, a janitor's closet or something like that, I would view that as protected speech under the First Amendment. However, the university does have their own codes of conduct. Those codes of conduct should protect speech to some degree. There might be some limitations depending on the workplace. If it's interfering with the environment, the learning environment of the students or something like that, that's something that the university has to deem if that's a problem. I can't speak exactly how a university would treat that, but that's the chair's response in my view.
Follow up after Ms. Walters.
Yeah, I would just like to say this bill does not address that, sir. So it would not either prohibit it or support it. It just doesn't address that situation.
Okay. Then again, I don't want to go too deep in the weeds, but I want to make sure because this is an important bill. So because what triggered that was the universities have their own code of conduct. So does this bill usurp each individual university's code of conduct? Or who's the lead? I don't want to try to confuse the situation, but if each university has whatever they see as protected speech, or if they have as displays, would this now trump individual universities' code of conduct on things like matters like this?
Jill, if you'd like to respond.
So, sir, I think the only time this would cross streams of that is if the code of conduct says, and I'm making this up, please know, that it said Kansas State University's code of conduct for every employee, faculty member, student is that they have diversity, inclusion, and patriotism as they walk across campus and in all conduct that they have. But that's still just the code of conduct. It would then have to apply and every applicant who applies for a job or for a promotion must do DEI and patriotism. And then I think it would cross, but just having a code of conduct that says X, Y, and Z is not contemplated in this, sir.
Very good. Thank you. Thank you, Mr. Chairman.
We'll go to Representative Fairchild next.
Thank you, Mr. Chairman. We took the term or related topics out of this, basically in order to make this more specific and less expansive to other things. But then it makes it sound like, you know, that the word patriotism sort of has a broad meaning too, if it can apply to all sorts of different things like capitalism or socialism or all kinds of different political ideologies. And so, I mean, it just sort of seems like the word patriotism could be fairly similar in how it's defined or interpreted or as the phrase or related topics. I mean, kind of makes it sound like it's kind of the same thing, that patriotism could be applied pretty broadly and could be applied to just about anything. I mean, if the representative who asked that question about the word, if he wanted to offer a conceptual amendment to the bill, if he wanted to take that out, I mean, that's probably something that he could do if he wanted to.
Thank you, Mr. Chair.
Representative Smith?
Truthfully, I wouldn't mind if that word was not in there, but thank you.
Representative Woodard?
Mr. Chair, I was just going to say we're on an amendment, and that phrase isn't part of the amendment. So can we come back to this discussion after we take action on this amendment?
I think that would be appropriate. Point taken. So are there any other questions for our revisor about this balloon amendment? If not, I'll Representative Wassinger.
Yes, thank you, Mr. Chair. I appreciate the amendment. I was concerned about the amount of penalty, and I think all of the all people that were in that discussion agreed that that was perhaps over the top. Let's put it that way. So I appreciate it being changed, and I appreciate the fact that it is there is a logical conclusion of how to deal with violations, etc. So I think what I want to say is that discrimination is wrong in any form, anywhere. And that the problem with DEI is that it allows for discrimination in its premise. And so it's a reasonable way to deal with things. It gives many different levels to decide whether someone's gone overboard or something's, you know, not as much of a violation. And I appreciate that, and I urge everyone's support for the amendment. Thank you, Mr. Chair.
Is there any further discussion or questions? Representative Amix.
Thank you, Mr. Chairman, and echo Representative from Hayes' comments the other day that I made. I truly believe that the amount of fines that just out of line. But anyway, I appreciate all the work that you and others have done to make sure that this is handled in such a way. So I want to thank you for that. I think we're always going to have time when we're going to have difference of opinion, probably on base bills. But this particular case, I do want you to know, I do appreciate all the work that you and others have done to make sure that this is something can be handled in a logical way. Thank you very much.
Thank you, Representative. Go to Vice Chair Sanders.
And along that same lines, what I like about the amendment is that it offers remedies before any financial amount is deemed due.
Are there any other questions for our revisor? Thank you, Jill. We appreciate your feedback and expertise in helping us with this legislation. I won't belabor any of the points that have been made too much, but I just want to acknowledge that we did remove the cause of civil action from the bill. It's no longer there. It does provide an opportunity for someone to file a complaint and also an institution to remedy any found violation. And so I think it's important that those institutions have an opportunity to make right or to cure whatever violation may have occurred, and it not to be punitive in nature. I think by the time you do get to that point with the Kansas Attorney General, And I wouldn't think our institutions would let it get that far, because that would, there's so many opportunities really to fix or have a course correction on that. So additionally, the penalty was lowered substantially as well. There's one section I would like to highlight. It's towards the bottom. It's right around, I guess it's part of the balloon. It's about the state scholarship program. So I wanted to ask KLRD, our fiscal analyst, Brianna Horton, to let us know what institutions are eligible for that, because in this bill, post-secondary educational institution means any public university, municipal university, community college, and technical college. So I want to make sure it's much broader than just the Regent schools. So Brianna?
Mr. Chair, Committee, the list I am going to read off is also on the Board of Regents website. So if you go down to the Kansas State Scholarship, there will be a document that pulls up that lists all of them. So it is quite a long list. If I need to stop, that's fine. But it's all of the Regents universities. The state scholarship program is also for the private and independent colleges. And then so it's also for the community colleges, which is Allen, Baker, Barclay, Barton, Benedictine, Bethany, Bethel, Butler, Central Christian, Cloud County, Coffeyville, Kobe, Cowley, Dodge City, Donnelly, Emporia, Flint Hills, Fort Hays, Fort Scott, Friends, Garden City, Heston, Highland Community College, Hutchinson, Independence, Johnson County Community College, Kansas City, Kansas, Kansas State, Kansas Wesleyan, Labette, Manhattan Area Technical College, Manhattan Christian College, McPherson, Mid-America Nazarene, Nesho County, Newman University, North Central Kansas Technical Colleges, Northwest Kansas Technical Colleges, Ottawa University, Pittsburgh State, Pratt Community College, Salina Area Tech, Seward, Southwestern College, Sterling, Tabor, University of Kansas, the Medical Center, University of St. Mary, Washburn, Washburn Tech, Wichita State, and then Wichita Tech as well. And this list was updated back in September of 2023.
Thank you, Brianna. I just wanted that to be on the record for the committee. If anybody had questions about what that scholarship and who it applied to, and making that connection of the definition of post-secondary educational institution in the bill. With that, I'll go ahead and close on my amendment unless there's any further discussion. So I close. So all in favor of the balloon amendment signify by saying aye. Aye. All opposed, nay. Motion carries. So now we are back on the bill, HB 2460. So we're back on the bill. Are there any other amendments or representative or discussion on the bill? Representative Smith.
Forgive me for, I need to walk through this, have some help. But I would like to take that word patriotism out. And whether it passes or not, I would feel better that it wasn't in there. So I'd like to make an amendment that we take that one word out and go with the rest of the bill.
Thank you. Is there a second to Representative Smith? It's been seconded by Representative Rajas. Is there discussion on the friendly conceptual amendment to delete patriotism from HB 2460? Representative Fairchild.
Thank you, Mr. Chairman. I support the amendment. I think it would make the bill a lot more clear and a lot less confusing. I think people would just have a lot of questions about what patriotism means or how it's defined. So I think it's a good amendment.
Okay, next, go to Representative
Mr.
Rogers.
Chairman, I just for point, I want to make sure I believe that it is not in the in the balloon we just passed, but it will be on line 12 and line 18. I believe that's the only two places the patriotism shows up. And so that's, I'm assuming, Representative Smith, that you want to take out both those, that word in both those lines, correct?
Yes.
Thank you, Mr. Chairman.
Thank you, Representative, for helping clarify that. So that's line or section 1, line 12 and line 18. Is there further discussion? If not, Representative Smith, you may close on your motion.
I close.
Okay, it's been moved and seconded to strike the word patriotism in line 12 and line 18 of House Bill 2460. And line 29. If that's the intent, there's also line 29, and in the title of the bill, there's the word patriotism.
Thank you, Mr. Chair. That was my intent. So yes.
Representative, was it Rogers you seconded? Is
Yes.
that okay? You can,
Well, I'm sorry, I'm going back in line 29. And then I'm trying to find the balloon. What section is it in the balloon?
It's not in the balloon.
But we struck section, we struck line 29.
We didn't.
On page 1,
so page 1, yeah, I'm sorry.
okay, missed it. Then yes, that's second.
Mr. Chairman,
Vice Chair Sanders,
Thank
do you
you.
have a question?
could an alternate amendment be in order that we strike the word patriotism wherever it appears?
Okay, so it's been moved and seconded to strike patriotism from House Bill 2460 wherever it appears. Any discussion on the revised motion? Representative Fairchild.
Thank you, Mr. Chairman. I just noticed something else, and I don't know if this is a problem or not, but on line 29, it still says or other topics, and we struck that out to other different places. I don't know if that's something we missed before, if we should have struck that out, that phrase out of that line too.
I think we can come back to that because I think it is a little bit different. But so the current motion is regarding patriotism, but we'll come to that next if that's okay. Is there any other discussion on the Smith amendment? Representative Wassinger.
Just as a stylistic, and you have to move the word or. Isn't there a or in front of? Or we just didn't put that? It's already in there. I apologize. Never mind. Thank you.
Is there any other further discussion on the Smith amendment? If not, Representative Smith, you may close on your motion.
Thank you, Mr. Chair. I close.
Okay, it's been moved and seconded to strike the word patriotism from the contents of House Bill 2460. All in favor, say aye.
Aye.
All opposed, nay. Motion carries. So now we can go to Representative Fairchild's concern in section 1. I guess it would be under subsection C 2. I believe I visited with the reviser about this. If the reviser could provide some context to the use of the word or other topics in that section, I would appreciate it. Thank you.
Thank you, Mr. Chairman and members of the committee. Why we left it there, or I left it there, is because this is the section of the bill that says an institution, could not prevent or restrict the academic freedom of faculty member to do research, writing, or publications about diversity, equity, inclusion, or other topics. And so this is saying nothing in the bill shall be construed to prohibit, basically, or restrict or limit academic freedom. And so in this instance, it's just slightly different than the other instances. Thank you.
Yeah, so that was another intent of the bill, is to ensure we're protecting academic freedom, diversity of intellectual thought, and those things on campus. So is there any other questions or concerns or amendments? Representative Fairchild, then I think we'll go to Representative Sawyer next.
Thank you, Mr. Chairman. I mean, this is a fairly minor point. The representative from Hayes brought it up, but I mean, that previous amendment, I don't know if it reads quite right grammatically unless we put the word "or" in front of inclusion, because I mean, it just reads including a pledge or statement regarding diversity, equity, inclusion. So it really should be "or" grammatically. I don't know if that really matters.
Jill, if you'd like to comment on the grammatical nature of that. Yeah.
In these instances, sir, I would generally talk to the chair and say, for grammatical correctness, we would need to add that "or," and that we just do it as part of a cleanup of the intent of the committee always controls. So we would never want to change the intent of the committee, but as much as possible, try to have a grammatically correct sentence.
So that doesn't need to be offered as an amendment. Then you can just do that on your own.
Representative Sawyer.
Okay, I have an amendment. I'd like to strike on line 11, strike the word "including," and then strike "a pledge or statement regarding diversity, equity, and inclusion." Just strike all that. And the same thing on line 17, strike "including a pledge or statement regarding diversity, equity, or inclusion." I'll explain my amendment.
Is there copies for the committee members?
No, it's
okay.
just straight striking.
Okay, so it's been moved and seconded to strike from lines. Could you tell me the lines again?
Okay, on line 11, right after the word "movement," strike "including a pledge or statement regarding diversity, equity, and inclusion." So all those words before patriotism.
Okay.
And the same thing on line 17.
Okay.
Go after "movement," strike "including a pledge or statement regarding diversity, equity, or inclusion."
Okay, very good. Now we can have.
Right.
If you'd like,
let me explain
explain your amendment first, then we can have discussion on it. Thank you.
When I listened to the hearing, I mean, it sounded to me the concern is we don't want people to be discriminated against for the political ideology, ideologically. We don't want conservatives to be discriminated against, or liberals, or whatever your beliefs are. I don't understand why those other words are in there, because I don't understand why anybody would be against equity or being inclusive or diversity. Those are all good qualities, but I do understand why we would not want to discriminate somebody for their political ideology. So I think taking those words out there gets the gist of what you were talking about, what the problem is. So that's what I'm trying to narrow it down to.
Okay. Are there other questions? I'll go to Representative Woodard, then I'll go to Vice Chair Sanders after that.
Thank you, Mr. Chair. I would support the amendment. I think it was incredibly clear during the hearings and has been the theme of the last couple of years, whether it's DEI, CRT. These things continue to come up and be topics of conversation, yet no one can define what they mean. Even the post-audit came back with each institution having different definitions of what diversity, equity, and inclusion includes. And so without a definition section of a bill, without defining what those words mean, it seems like it's superfluous, word of the day. And so probably used that wrong, but okay, great, thanks. But I just feel like we're continuing down this path of passing bills in response to issues that aren't real, whether rather than just being able to figure it out. Until we know what diversity means across the board, until we know what equity means across the board, until we know what inclusion means across the board, we shouldn't be passing legislation dealing with it. So I support the amendment. If we can define those in the future, you can earn my vote on a bill like this. Thank you, Mr. Chair.
Thank you, Representative. Next, we'll go to Vice Chair Sanders.
Thank you, Mr. Chair. Would the maker of the amendment concede that this would change the entire nature of the bill?
Well, I don't know. I mean, again, we don't have a definition of what we're talking about when we talk about diversity, equitable, and inclusion. And to me, those are really good qualities. I don't quite understand. I don't really understand that part when you guys talk why that's in there. I do understand we don't want to discriminate against people for their support or opposition to any political ideology or movement. I mean, that to me says, I thought, what you were trying to get at. I really don't understand why those words are in there. I mean, those are good qualities. They're undefined. I don't know, why we put them in there.
So those were put in there because specifically this is what universities are or were requiring of their applicants. And that is not constitutional. It's discriminatory. And so we have to identify what it is that we're seeking to address. And universities know what diversity, equity, and inclusion are. I know they might not share a common exact definition, but I think it's pretty common knowledge that, they're investing a lot of money in diversity, equity, and inclusion programs, which this bill does not prohibit universities from engaging in DEI programs. This is narrow in focus to employment, gaining admission, or educational aid. So this is to protect the constitutional rights of any applicant that comes to our universities in Kansas. So that's the focus of this bill. And it addresses the concern that has been made public in testimony that universities are requiring these unnecessary and unconstitutional statements.
Sorry, I guess I still just don't understand it. Are we wanting? I don't know why we would want people working at our universities who aren't inclusive, who aren't equitable. I would, I don't quite get. I just don't get that part, I guess. I mean, are we trying to go back? When I was a kid, most of our universities, the students, faculty, everybody, they're pretty much all white and mostly male, and Title IX came along in 1971, promoted gender equity. And today, most of our campuses are probably more female than male. And that's probably back when we start talking about our universities trying to be more diverse and more equitable, we're probably going back to about that time period. And I guess I don't see anything wrong with that. Now, I do see something wrong when you discriminate against somebody because of their political ideology or movement. I get that. But I don't understand what is bad about wanting people that are inclusive and equitable. How can anybody be against that?
If I may respond. So this bill isn't saying that diversity, equity, and inclusion are bad traits. It's just saying that universities are prohibited from compelling an applicant to produce a statement or adherence to diversity, equity, and inclusion in order to be considered for employment or admissions or for educational aid at an institution. Because what happens is there are rubrics set up by hiring committees or whatever the term is, and they are graded on how well they adhere or how strongly they support diversity, equity, and inclusion. And that turns out to be a discriminatory practice. So if universities want to keep doing that, they are going to be liable because it violates constitutional rights of citizens in this country who are seeking employment. And so there is a liability for universities to continue on down this path. This helps provide a remedy and direction for our universities and post-secondary educational institutions. It gives them clarification that no, the state legislature is saying, no, you're prohibited from doing that. You can certainly continue to ask those certain questions that are within the bounds of the law in an interview, right? You can still ask people about their experiences working with a diverse group of people. You know, if you're a teacher, do you have experiences working with a diversity of students or parents? How would you handle this situation? There's all sorts of opportunities for people to gain information about someone's character or how they would handle a situation. So, Representative Sawyer.
I guess I just don't understand. To me, these are good qualities. I don't know why we wouldn't want university to ask about these things. I mean, I'm just, like I said, I get the part about you don't want to discriminate against people because of their political beliefs, but I don't understand what's wrong with making sure people are equitable and inclusive and include people. You know, I just have a hard time with that.
Thank you, Representative. We'll go to Vice Chair Sanders.
Thank you, Mr. Chairman. There is a certain segment of the population that views diversity, equity, and inclusion as a negative thing. And when it's used in a negative way, I'd like to refer back to what Justice Stewart said back in 1963 when talking about a pornography case that came before the Supreme Court. I can't give you a definition of pornography, but I know it when I see it. And relative to trying to give a definition of the negative consequences of diversity, equity, and inclusion, I may not be able to give you an explanation or a definition, but I'd know it when I saw it.
Is there any other discussion on House Bill 2460 or 2460's Sawyer Amendment? Sorry. Any other discussion on the Sawyer Amendment? If not, Representative Sawyer, if you'd like to close on your amendment.
Yeah, I'll close my amendment. I understand we don't want to discriminate against people because their political ideology or support or opposition for a movement. I'm fine with that. I think it's important that our universities promote inclusion. I think it's important they're equitable. I think that we should support diversity. So that's the purpose of my amendment. I move my amendment.
It's been moved. Representative Sawyer has moved his amendment. All in favor of the Sawyer Amendment signify by saying aye. All opposed, nay.
Nay.
It appears the noes have it. A motion fails. We are back on the bill, HB 2460. Is there further discussion? Any other proposed amendments or modifications? If not, what is the will of the committee?
Mr.
Vice Chair Sanders.
Thank you. Mr. Chairman, I move that HB 2460 be amended by adopting the committee amendments and that the two substitutions for HB 2460 be passed.
It's been moved and seconded by Representative Wassinger. Now we can have discussion. Representative, you have a question. I'm sorry.
Are we putting this into a substitute bill since it's been dramatically altered?
So my understanding is the way the motion was offered, it would allow the bill to become a kind of a cleaner, a substitute bill. So it's yes. My answer is yes. So that way the format is a little bit more clear in the committee report. All in favor of the motion of House Bill 2460 signify by saying aye. All opposed, nay. The ayes have it. Representative Woodard?
Like my no vote recorded. Thank you, Mr. Chairman.
The motion carries, and Representative Woodard, Amix, and Sawyer wish to have their votes recorded as no. Okay, so is there any other items today? I don't have anything else, but did anybody have any cleanup items that we needed to do as a committee? Okay, Vice Chair Sanders has worked on the committee report for HB 2705, and hopefully we can get that submitted in the near future to get that to the leadership, or to the clerk, I should say. And we'll begin working on the committee report for, or bill brief, I should say, for 2460. That being said, I do appreciate the committee's work on this bill. I think it's an important step in addressing this particular issue, and I appreciate everybody's ideas that they've brought to the table, and look forward to working with you in the future. The meeting is adjourned.